like whoever has to speak, they can just turn on the microphone then, because it avoids any disturbance. Yeah.
I have this question for you. What do you mean by learning public speaking skills?
Sibran, we can
Does this mean that we have to learn body language and vocal variety so we can deliver a content?
Yes. A very good evening, everyone. We are honored to welcome all the dignitaries, academicians, industry professionals, and participants to day one of the Pan-India Faculty Development Program on Intellectual Property Rights conducted by H&GH Mansukhani Institute of Management in association with Board of Industry Academia Partnerships. We sincerely thank everyone attending for the overwhelming response, as we have with us participants not only from across the country, but across the globe, including the United States of America and Canada. Now, please let us begin our session on an auspicious note with the Saraswati Vandana, offering our respect and seeking guidance from the goddess of knowledge.
Ya kundendu tusharhara dhavala, ya shubhravastravruta, ya veena varadanda manditakara, ya shweta
Quick word about BIAP. We at BIAP are concerned with enhancing the collective potential of students. We aim to bridge the gap between industry and academia, igniting minds and awakening hearts. That's our vision and mission. The primary objective of the session is to echo its vision statement. We have a team of experienced trainers, facilitators, and academicians who have catered to varied learner groups, right from school children, college students, college faculty, army officers, police officers, doctors, lawyers, self-help groups, gram panchayats, senior citizens associations, and many more. In its short tenure, BIAP has conducted numerous investor awareness programs and various customized training programs and impacted the lives of more than 3 lakh individuals. We aim at doing so during these challenging times as well, which is why we have come up with initiatives like webinar management, where BIAP, along with colleges like MIM, continue to educate individuals through live seminars and webinars on various topics. These seminars are available on our YouTube channel. H&GH Mansukhani Institute of Management was established in the year 2005 under the aegis of Hyderabad Sindh National Collegiate Board, one of the oldest and most reputed trusts in India. It is the first postgraduate management institute between Thane and Karjat conducting PhD management and MMS. The program is approved by AICTE and affiliated to the University of Mumbai. MIM is nurtured under the able guidance of eminent industrialists and academicians. President of the board, Dr. Kishu Mansukhani, Dr. Niranjan Hiranandani as Provost of HSNC Cluster University, Mr. Anil Harish, an eminent legal professional, Ms. Maya Shahani, and Mr. Lal Chelaram. MIM aims at the holistic development of an individual by a professionally managed team comprising of highly experienced academicians and corporates. At MIM, the students are not only prepared to excel in academics and the corporate, but also their young minds are trained to overcome the barriers in the corporate world. A unique pedagogy, excellent results, a high percentage of students embracing entrepreneurship, alumni excelling in corporate and international placements makes MIM a sought-after institute. We have with us today Dr. Swati M. Sabale, Director, H&GH Mansukhani Institute of Management. She is PhD Management, MBA, and an ADCSSAA, DCS, and BSc in microbiology. She is specialized in marketing management and personnel management. She is also avidly interested in research. Her field of interest includes brand management and consumer behavior. She is also associated as a consultant in OD and sales and marketing research. She is an approved research guide by University of Mumbai and Pahir. She currently has 8 research students and 4 students who have completed their PhD. She has won various awards under Green Initiative by KDMC. She has been involved in more than a score of FDPs and trainings and has experience of over 25 years. I would now like to take this opportunity to welcome ma'am.
Thank you, Gibran. Thank you, Gibran.
Pleasure, ma'am.
Yeah. Good evening, friends. On behalf of H&GH Mansukhani Institute of Management, I welcome you all to this 2-day FDP on IPR. We at Mansukhani Institute of Management, is popularly known as MIM, started our journey in the year 2005. We conduct a 2 years Masters in Management Studies program affiliated to the University of Mumbai and approved by AICTE. We also conduct a PhD in Management program affiliated to the University of Mumbai. Faculty development has always been our area of focus, as an excellent faculty is a key to an excellent institution. The aim of this FDP is to get acquainted with the basics of IPR. As academicians, our greatest asset is our intellectual property. And who else can protect it better than us? Intellectual property is the line drawn around information which asserts that despite having been set loose in the world and being created out of an individual's relationship with the world, that information retains some connection with its author that allows a person some connection and control over how it is replicated and used. Our eminent speakers will give us a deeper insight to this. I warmly welcome our speakers, Mr. Abhishek Nangia and Ms. Shabnam Khan, to the program. Now, I hand over the program to Ms. Dr. Nikita Khatwani, our senior most faculty.
Thank you so much, Dr. Swati Sable ma'am. Good evening, everyone. It's a great pleasure for me to introduce the first speaker of our FDP, Mr. Abhishek Nagia, who is going to talk to us about the basics of intellectual property rights. In today's globally competitive environment, intellectual property has gained a center stage and has attained more focus and attention as knowledge and innovation have become the engines of development and growth. And in this world, those who have the creative minds and ability should feel assured that not only their efforts have been duly recognized, but it is secured in a specific manner. Our speaker for the day, Mr. Abhishek Nagia, has been doing this since 14 years. Sir is currently a partner with RNA Technology and IP attorneys. As discussed, he has over 14 years of post-qualification experience and advises clients on a wide range of intellectual property matters, including brand clearances, oppositions, cancellations, infringement proceedings, and domain name disputes. Sir regularly appears before various forums, including the Intellectual Property Appellate Board, District and High Courts, Trademark Registry, and the Registrar of Companies. Till today, Sir has been invited to address a wide range of audiences, including the Indian custom officials, police officials, students at law colleges, chartered accountants, and company secretaries on areas such as anti-counterfeiting, IT Act, and emerging IP issues in cyberspace. In 2017, Sir was selected to attend a training course for IP protection lawyers held in Tokyo. Apart from his contribution to the above areas, Sir has also written articles on various topics of intellectual property law, which have been published in various print and electronic media, including the Ainishi magazine published by Japan Patent Office. I now request Sir to take over the FDP and enlighten us with all the basic intellectual property rights. Thank you, everyone. Over to you, Abhishek, sir.
Is my screen visible to all?
Yeah.
Yes,
Thank
sir.
you. Thank you. Thank you, Dr. Nikita ma'am, for your kind introduction and for inviting me to speak on this topic, basics of IPR. I will try to keep the session simple, easy to understand, and use less of legal language and speak in simple terms so that it's easier to understand and it may at the same time make it interesting for the listeners. So let's start with the topic. What exactly is intellectual property? The traditional concept as we have understood property is the movable property and the immovable property. For example, a piece of land. So this is what traditionally we have understood property as. However, intellectual property is something which is a creation of the mind and something which is unique to the individual and commonly referred to as intellectual property rights. Intellectual property rights are intangible in nature, territorial, and time bound. By this, I mean it's limited to the geographical boundaries and has a limited time period. For example, trademark is for 10 years, renewable for further 10 years. Likewise, the other forms of IP, which I will discuss. So if I have to give an example in a very simple terms, intellectual property could be a brand name. It could be a literary or a artistic work, a book written by me, or a new invention created by an individual, new design for a product, and so on. So there are 6 types of intellectual properties which are there, and I'll discuss each one of them. So to give the broad headings, these are trademarks, copyrights, design, patent, trade secret, and geographical indication. I think the interesting part you will see that all of them has each trade an act for the subject. For example, the trademarks has a Trademarks Act, copyright, Copyright Act. For designs, we have another legislation, Designs Act, Patents Act. Trade secret doesn't have any act. Geographical indication has another act called the GI Act. So the interesting aspect of this is that we do not have a common act, but a different act for each intellectual property. And whereas the trade secrets, there is no specific legislation for this. This is more of judiciary-based law. It has origins in the US, and trade secret is something, if I have to define it, is something which has economic benefit to the business and is useful to it, and at the same time the business would like to protect it. So as we go on, and I will explain the basics of each of the 6 IPs that I have just briefly touched upon, and to understand them in detail. Trademarks. Trademarks is a brand name, includes a logo, a slogan, or a brand. And it's simply the name of a product. For example, I think we use trademarks in our daily lives. For example, if I have to look at these brand names, which they are mentioned on the page, for example, Tata, Coca-Cola, Infosys, Intel Inside. I think all these are brand names, and these are popular brand names which need no introduction to all of us. And in some form or the other, we all have used in our daily lives. So it is something which has an idea, basically gives an identity to the product. For example, if everyone was called with a name, had a generic name, it would be difficult to distinguish from where it is coming from. So the names help us to distinguish from the source from where the brand is coming from. For example, the Pepsi, Shell, Tata, Sony, these are the few names which are listed here. And interestingly, I found that BIAP is also a registered trademark in class 41 and for educational services. So this is, these are the few trademarks for illustrative examples. And in trademarks, there are classes 1 to 45 for seeking statutory protection. And there are different goods and services. Classes 1 to 35, 1 to 34 is the goods, and from 35 onwards is the services description. So based on the goods, the classes, the classes are differentiated. And also the Trademarks Act makes a provision for the well-known marks. The well-known marks, to put it in simple terms, are given protection in respect of different goods as well. So they stand on a higher legal footing as compared to a trademark. Now, what do trademarks do? The purpose of the trademarks is to indicate to the purchaser the source or the origin of the goods or services. Essentially, to put it in simple terms, from where the product is coming, to let the consumers know. So for example, if it's an Indigo Airlines, the name in itself tells you that the source of the product or a service. Peter England is for shirts, HDFC Bank for banking services. So from looking at a distance, we are able to identify from looking at the brand names about which brand it is. Another important concept in the trademarks law is the priority given to first to use than first to register. Speaking in simple terms, so anyone who uses the brand name first has a superior right than the one who registers it first. For example, if I start using the mark today and there is someone else who files an application later on, the one who has started using it first will have a superior right. And so that's it on the user part. And another important aspect is the applications can be filed on a proposed to be used basis or with a user claim. The user claim becomes very, very crucial in contentious cases and could be a bone of contention in a litigation proceedings. Now, explaining the meaning of the TM, SM, or symbol R. I think we all would have seen with the brands the TM symbol or the SM symbol. So the moment and you start file, then application is filed, we can use a TM logo alongside the brand. So it is not necessary that until the registration is granted that we have to wait for it. It can be immediately used the moment and then application is filed. An R symbol can only be used when the mark is registered. And if it is used earlier, which means the application is pending and has not proceeded to registration, it is a punishable offense and action can be taken under the law. Now, is my mark registrable? This is a very common question which we all face while selecting a brand name. I think some of the common pointers which we have to keep in mind is the mark should not be identical or similar to an earlier or a registered mark. Personal names, surnames, or three-letter marks, if they are not, do not form a pronunciable word. Marks, these which are purely descriptive in nature. I think here I would like to emphasize that marks which are descriptive in nature, these are not good marks. So at the time of thinking about a brand name, I think we should spend time what could be a brand name. Generally, descriptive marks are difficult to protect and should be avoided in adopting them. And the other marks for example, marks which offend the religious susceptibilities of any community, marks having geographical significance. For example, if my mark has India, Calcutta, or a name of a state, nobody can be granted exclusive monopoly over geographical names as well. Duration of a trademark. So as I just mentioned in my slide 1, that trademark rights are territorial and time bound. So the initial term of a trademark is 10 years from the date of application, and subsequently it can be renewed for a further 10-year period. So for likewise, the registration can be continuously renewed at the end of one 10-year period. So just to give you an example, of the real versus copied examples, we had the Starbucks coffee versus the Sadar Baksh coffee. There was a case before the High Court which was filed by the Starbucks coffee. They had a problem with the name as well as the logo. Sadar Baksh, because they felt that the color combination and the name as well had a phonetic similarity with Starbucks. Likewise, I think if you see the image, Coolgate versus Colgate, here the packaging as well as the name is very, very close. Under Armour, if see, there's a very slight differentiation in the logo, and the way so it's a, and the way it is written, the background, the color red, I think it gives a the visual impression is it's looks very similar to Under Armour. And likewise, in the last image as well, I think it's very difficult to make out between which is the original and the fake. So these are the few examples which distinguish between the real and the copied ones. So the second type of intellectual property is the copyright. Copyright is a legal right given to the creator over his original, literary, dramatic, musical, artistic, cinematography films, sound recording, so that the creator can reproduce, publish, and sell his work. As the name suggests, copyright, it is not the right to copy, rather, it's a negative right against the copying of others. And for example, the movie scripts, the books, articles, sound recordings, software, these are just some of the examples. And a very fundamental principle of copyright is copyright does not subsist in an idea, it subsists in expression of ideas. To take an example, all of us would be aware of the controversy which had arisen in the Bollywood version of the two movies, Ujra Chaman versus Bala. So the bone of contention in that was both movies were based on premature balding, and the directors of the movie had an issue that the sequencing, the trailer, and the captions used in the movie Bala were on the similar lines. So essentially, what I'm trying to say here is there can be two movies on the same concept, but the impression on looking the other should not be such that it leads to a conclusion that it has been copied from the other one. So there can be different movies on the balding, but the manner or expression of ideas should not be the same. Or in other words, if it leads to a conclusion that it has been copied from the other, then it would amount to an offense under the Act. So just to give an examples of the types of the copyrights that we have is the literary work, the musical work, artistic work, dramatic, sound recording, and cinematographic works. So in the literary work, we can have the books, poems, lyrics, stories, computer software. And the term of the literary work is life of the author plus 60 years from the death of the author. And in musical works, you can have the musical tones, the tunes, and the term here is the life of the author plus 60 years from the death of the author. Artistic work, it could be a painting, a drawing, a photograph as well. So Likewise, the term here is life of the author plus 60 years. Dramatic works, examples of this can be the plays, speeches, the speech which is given to the public. Again, here the term is the same, the life of the author plus 60 years. Recording includes songs and the podcast. The term is 60 years from the publication. And in the last category is the movies, TV shows, and the advertisements. And the term of the copyright is 60 years from the publication date. Now, how is copyright protected in India? The applications can be made to the Registrar of Copyrights. So another interesting point of the copyright law is the copyright law is international in nature. India is a signatory to the Berne Convention as well as Universal Copyright Convention. The Berne Convention essentially protects the other signatory countries. That is, the work created in the countries will automatically be protected in India. There are around 180 countries which have signed the Berne Convention, and so the work registered in these countries automatically becomes registered in India without seeking a formal registration. However, it is still advisable to seek a registration for the copyrighted work from an enforcement perspective. Now, coming to the duration of the copyright registration, I think generally the term of the copyright protection is the life of the author plus 60 years, as we have all seen, except the cinematographic work, which has 60 years from the publication date, as well as the sound recording. So generally the term is life of the author plus 60 years. Another interesting example of the copyright is the photocopying case. I think all of us use in the colleges is the photocopying, photocopy of the course materials. So one of the interesting cases that had reached the Delhi High Court, I think it was covered in the media as well, was that the books of the publisher were being photocopied without the consent of the publisher. So a case was brought before the High Court, and in this case, the issue was whether the photocopying can be done by the photocopier without taking the consent of the publisher. The Delhi High Court essentially initially came to a finding that this the ruled in favor of the publisher, but eventually, I think after long and drawn proceedings between the parties, the publisher withdrew the case after the division bench had ruled in favor of the photocopier and the students, saying on the basis that access to the education, a reasonable access should be given to the students, and on that basis, the photocopying of the books, which we normally see happening in the college areas as a part of the course material, became legitimate after this. So coming to the next form of intellectual property is the designs. Design is something which appeals to the eye and has a visual consideration for protection. It protects the creative shape of a product and something which is the outer appearance or aesthetic aspect of the product which makes it visually appealing. And the thing to be kept in mind is functionality is not the consideration. So it's the outer appearance which I am looking at, is the shape of the product here. For example, a shape of a Kinley bottle, Saffola jar, Coke bottles, a TV remote, pen, all such are registrable as a design. So if you can see here, these are the different shapes of a bottle. It could be a perfume bottle even, or a oil bottle that could form a subject matter of design. So the next question is, what can be registered as a design? So one of the essential prerequisites is the design should be original. It should not have been published anywhere, not disclosed to the public. Likewise, it should be distinguishable. It should not be, resemble from the earlier designs, registered designs, or something not against the public morality. So, and functionality, as I mentioned, is not the relevant criteria. So we are more looking as the aesthetic aspect of the design, something which is visually appealing. The term of the design registration is 10 years from the date of registration, which is the date of application, and it is further it can be further renewed for a period of 5 years. So the next form in intellectual property is the patents. Patents are essentially the exclusive rights given to the person for a full disclosure of the invention. These rights are territorial, and the exclusivity is limited to India. So this is, to put it in simple terms, it gives the right to a patentee to commercially exploit the invention. So the examples of the patent are mostly in the pharmaceutical side, the technology, the machines, the printer, the drones. So these are the examples, the common examples of the patents. So what is the criteria of a new invention for which a patent can be obtained? The first and the foremost is the novelty. The invention should not have been made public, not even by yourself. So the moment it is disclosed to someone else, it will not be eligible for protection under the Act. Inventive step. By this, I mean to say that this should involve a technical advancement as compared to existing knowledge, not in the eyes of a common person, but to a person who is skilled in the art. And thirdly, industrial application. It should be capable of being used. Likewise, the patent also has a term. It is 20 years from the date of filing. That is the application date. Now, this is a very interesting concept. This is a very interesting concept called the trade secrets. Trade secrets, as I mentioned briefly in the introduction, there is no specific legislation unlike the other IPs. This is a US-based concept, and this is something which has an economic value, and the business would like to protect it. And for example of a trade secret could be a lot of employees in the organization, as we see, have access to the client list. The list could have the names of the vendors, the addresses of the vendors, the prices, the price list, and the email addresses, the contact details. So something which is proprietary to the organization. So anything which is confidential in nature and the business wants to protect it can be considered, and which is confidential in nature can be labeled as a trade secret. And reasonable efforts are made by the organization to maintain its secrecy at the same time. So examples which I just mentioned, it could be these lists, the marketing strategy, the formula or the business plan, the processes, the techniques. And it's very common in the food industry to have the trade secrets. For example, the Coca-Cola, the drink that we have, and the KFC chicken formula. These are trade secrets. And in India, these are protected. The trade secret law is protected through the other enactments that we have, that is the contract law and the copyright law and the other enactments. So there is no specific legislation for the trade secret, but the rights are enforced through other legislations. Geographical indications. Geographical indications essentially are indications which define the goods originating from a particular territory, a state, locality, or a region. For example, the product coming from a particular region has particular, the characteristics which are which can be related to a particular region. For example, we commonly refer to the Nagpur oranges, the Agra Petha. It's the region in that we have in mind. We say that this region is famous for. So the geographical indications essentially define the goods as originating from a particular part of the country or the territory of another country. So these are just the examples. If you can see on the screen, the basmati rice, the Darjeeling tea, Mysore silk from Karnataka, Feni in Goa. So all of these refer to a geographical indication. So as you will see, we have touched the basics of the IPs, trademarks, the patents, the design, copyright, and the geographical indication. So here is a comparative analysis of the protection, the the government fees that is involved in patent. Starting from trademarks, you will see that the initial term is 10 years and further extendable with a 10-year block. And the fees is 9,000 rupees for the companies, and if the entity is a startup or an individual, this is a 45. The fees is reduced by 50%, and the registration happens quite quickly. Within 12 months, in a smooth case, the certificate is granted, and the head office is in Mumbai, and there are other offices in Delhi, Mumbai, Chennai, Kolkata, and Ahmedabad. And any appeal, IPAB is the last column. So if there is any appeal that needs to be filed, it has to be filed before the Intellectual Property Appellate Board, and in short, we call it the IPAB. Likewise, the patent has a 20 years term. The government fee for filing an application is 8,000 for the legal entity, and for a startup, you would see it's 1,600. I think the government, with a view to encourage innovation, has has a discounted fee for the startups. 4 to 5 years, there are various stages involved in the grant of a patent. So it takes about 4 to 5 years. The head office is in Delhi, and there are various offices: Mumbai, Chennai, Delhi, and Kolkata. And the appeal, likewise, Again, in patents, from the patent office, an order of the patent office can be appealed before the IPAB. For design, the term is 10 years plus 5 years. And after that, once this period is over, it comes into public domain. So it's a exclusivity for a limited period of time, unlike trademarks, which you can continue to renew for on and on forever. The fees is 4,000 rupees, 1,000 rupees for a startup, 7 months, which is a quite quick. For a registration from to be granted, the head office is in Kolkata, and an appeal in the case of a design goes to the High Court. Unlike the other cases, it does not go to the IPAB, like I mentioned in the case of patent and trademark. In the copyright, you would have seen the term is generally life of the author plus 60 years, and the fees is quite nominal, considering the protection that we have. Looking at the term, it's a very big term that is granted by a copyright registration. It's 500 to 5,000 rupees, and the registration is pretty quick, 6 months. Then application, the head office is in Delhi, and an appeal from the copyright office can be again filed before the IPAB. In the GI, geographical indications, the term is 10 years. Further extendable renewal of 10 years, 5,000 rupees fee. And again, is the registration happens in less than 1 year, and the head office is in Chennai. And the appeals from the geographical indication registry lie before the IPAB. I think so. This is in the nutshell. I think if I had to sum it up, we can see the various IPs, the timelines, and the time period taken until registration. And another important thing is all the filings can be done online. So there were days in the previous years when physical filings used to happen. They are still a filing can still be done online, but yes, now in the digital times, the filings can be done online, and the hearings happen through video conferencing. So in the COVID times, the hearings are happening through video conferences. So all the offices have gone online now. And you can see from the time frame has come down in all the IPs drastically. Now, coming to the question, what is the commercial importance of IP rights? IP, it gives the exclusive rights. By exclusive rights, I mean it cannot be used by someone else once the mark, the brand name, or if you have a copyright, a design, or a patent, once you have a registration, it grants exclusivity. In other words, I don't need to prove that this belongs to me. So that the registration is a prima facie evidence that this belongs to the individual or the brand owner. It creates a positive image for an enterprise or a university, and it is useful for transfer of technology. I think it builds a positive image. By this, I mean people are able to relate to the brand. They form impressions once they see that this brand is so popular. Looking at if we have to see the Indigo Airlines or Reliance of these times, once we think of these brand names, then it leads to a positive image. People do form impressions about the brand names. Higher returns on investments. I think people do look at it. I think the amount of sales that a brand is making. So a lot more emphasis is given on the investments as well. Now, a question before all of us, this is a very common before all of us, is why should I register my IP? No, IP, we have, we are surrounded by IP in our daily lives, but is it actually necessary to register it? And the answer is, in very simple terms, yes, the IP must be registered. Provides statutory protection. By this, statutory means the protection granted by the Act to your brands, the inventions, and the works, and enhances the company's value and the image. People then take a note of it. Yes, these are brand names on existing on the register, and all, as I just mentioned, it also grants exclusivity. So once the mark is, or a brand name is registered, or the invention is, there's a patent or an invention, or a book, or a sound recording. So as per the timelines which I have just discussed, and avoids infringement. It acts as a deterrent. So, and people, when they get to know, it's, these registrations are like a notice to them. Yeah. So if any similar name, or something is adopted by them, which is very close, or gives the look and feel, which is a copy of the brand owner's name. So the brand owner could take an action against the other person. Enhances the goodwill and the reputation of the company. Again, it people think that this they have a high faith and the trust that has been placed in the hands of the brand owner, and attracts investment from the investors. So the investment from the investors, generally people look at the sales, the business which the company has done. At times people are just willing to put money into it. I think the recent example that we can see is the Reliance, the amount of funding which it has received in the last 2 months from the big brand names. So it helps the big brand names. It helps to get investors and strengthens the financial position of the company as well. Now, IP checklist. So a very common things, these are very common things which need to be kept in mind, is carry out trademark searches or prior art searches to see if the trademark or the patent applied is already in use. So a lot of clients, when they come to us, I think the first advice that we have is the search that should be done. There is no fun in having a brand name which ultimately, if there's a dispute brought against it, soon after its adoption. So it's very important to have a brand name which is clear. The title is clear. It's just like having a clear title to the IP as well. Just as we have it for the physical property, it's like clearing your title whenever you adopt it. A common example, I think, which comes to my mind as I'm speaking, is the Coronel, which, as you all would have heard, was brought by Patanjali recently as for boosting the immunity during these COVID times. And they had launched it earlier this month. And soon after the launch, there was another company which brought a case against them for that they also were the owners of the Coronel mark. So right after launch of the product, there was a lot of publicity which the Patanjali had done, and the court has restrained them from using it until the month end. So that the matter is coming up in the next week. So just in simple terms, the trademark clearance search is very, very important before, or a prior art search, just to see that there is no similar brand name or patent already in place. Register your IP. The advantage is the design is it gives you a statutory right, and it's easier to enforce. The moment you have to approach the courts, registration definitely helps you, and you don't need to prove the title. Another could be check if the domain name is available. In current times, everything has moved online. But there were days when they were brick and mortar shops only. Now it's no longer the case. Everyone does online shopping. I think we have the Amazons, the Flipkart, the Myntra. I think the moment, and especially in the lockdown, I think all of us have done online shoppings, or bought groceries, or or look for other things, probably, as we were not able to venture out to the market, so we all of us went online. So the message coming here is check if the brand name that you're adopting, if there is any website, if there is any domain name which is using that name. So if there's something very close to it, it's a red flag and an immediate no. So next is keeping the information confidential by using non-disclosure agreements, and having proper employment agreements in place to avoid any IP ownership conflicts and trade secrets against the employees. So it's very important to have the robust agreements in place to safeguard the IP. These agreements at the time of joining, these agreements are very, very important, so that the confidential information, which is proprietary and important for the business, remains within the organization and it does not go out. So have proper agreements in place, and these agreements, tomorrow, if required, these could be very useful to protect the IP. Likewise, have contractors assign their IP to you. For example, here I mean to say, if there are third parties which have been engaged to perform a certain type of IP, type of work which is capable of protection under the IP law, then have agreements in place by which they transfer the IP to you, so that tomorrow, if that IP becomes popular, it does not become a matter of dispute between the subcontractor and the one for and the organization. So have proper agreements in place, and at least there should be something in writing, if not an agreement, but at least something in writing must be there, by which the IP is transferred back to the company. Confidentiality agreements with employees, I think I have just mentioned. I think these are very, very important. Have proper safeguards in place, and another way is maintain proper records of the creation or the use of IP, which you have. I think a proper list is very, very essential. So coming to the enforcement side of is what are the remedies that I have as a brand owner if my IP is violated in the copyright, trademarks, design, patents, and geographical indications. In the civil remedy is I can file a suit for a permanent injunction, suit for infringement and passing off, claiming the following reliefs. Injunction is basically to restrain the other side from using the mark. Damages, rendition of accounts, the delivery of infringing copies. And there's also a provision of the local commissioner, whereby the infringing goods can be seized. This is a court-appointed commissioner. This is subject to. This is appointed by the courts, and the objective is to seize the infringing material from the defendant's premises. That is the one who has actually copied the IP. Criminal remedies, these are available only for copyright, trademarks, and the geographical indications. However, in cases of patents and design, we do not have the option of a criminal action. So the civil action can only be filed for these three categories. That is the copyrights, trademarks, and the geographical indications. So these are the services that we provide. We do patents, trademarks, copyrights, and for protection, the enforcement, consultation, and IP transactions, and that's it. Thank you.
Thank you so much, Abhishek sir, for this enlightening and informative session. It was really engaging to listen to you talk for the past hour or so, and it was really informative as well. Now, sir, we've been getting a lot of questions already. So if you would like to take up some questions.
Sure.
Yeah. I would also request all the participants to keep sending in their queries as we conduct this session so that we can engage sir with more and more questions as we can. Now, sir, one question that we've got is, who all are eligible to do an IPR course? This is Rajesham Siddojo.
IPR course, is it the law course or the general course?
I think, sir, that is the question, because the follow-up question to this is, can we pursue an IPR course without LLB?
Yes,
so,
I think anyone can do an IPR course. It's like a general course. These are there are various institutes which have specialized IP courses. I think the one which comes to my mind straight away is the Indian Law Institute in Delhi. It is just opposite the Supreme Court.
Okay. Thank you, sir. So another question is, under what conditions will the patency be rejected?
See, if it does not meet the three criteria which I mentioned, the novelty, the inventive step, and the industrial applicability, if these are not met, I think the patent will not be granted. And the very important condition is it should not have been disclosed to anyone, should not have been published anywhere. So a prior art search must be done before applying, for a patent. This is a very very important and one of the basic things which must be done before applying for a patent.
All right. Thank you, sir. Another question, sir, is this is Dr. Kalpana Chavan. She's asking, is patent in the field of education possible? And could you please explore some examples?
I think in the field of education, I think it would be a subject matter of the copyright. In the education field, we will have, the books. These would more, the relevant category would be the copyrights. We would more have I think in the technology, yes, we can have on the technology side, if there's any technology being implemented, being launched, then we can have the patents on it. But if I have to look from the educational perspective, if there are books, being launched, if there are anything, so it would, the relevant category would be a copyright protection.
All right. Thank you, sir. Another question from Sayan Bhattacharjee is, with the launch of GeoMeet recently, which has an interface which is very similar to Zoom, doesn't that lead to any violation of IPR laws?
Sorry, can you come again?
Yes, sir. So the question is that with the recently launched GeoMeet app, and with its similarity to Zoom, the similarity of the interface, doesn't that lead to an violation, let's say, of IPR laws?
I don't think. I think there is any violation per se with between the two platforms. I think these are although they have these on the same concept, but I think I do not foresee any violation between the two.
All right. Thank you, sir. Tanmay Prajapati is asking, is there any particular site or portal where we can check whether trademarks already exist?
Yes, that's a very important question. I think very interesting question. There's a website of the trademarks office. I think I'll share it as well. It's I think if you type it on Google, IP India, so of the intellectual property office. So there's they have an online portal where we can conduct a search of the trademarks which are already on the register, as well as the pending applications. So suppose if I have, as I mentioned, there are classes in the trademarks, 1 to 45. So depending if there's a search, if I'm applying for a clothing based brand, so it would be class 25. Then I search for a brand, and so it will give me a list of all the marks, which are valid, or which are abandoned also, or which are registered. So I can see all the marks online. So I don't have to, actually go to the trademarks office to find out these details. So just at a click of a button, these details can be found online.
Okay.
And in
Thank
fact,
you, sir.
to add further, I think all the IP offices in India now are on a digital platform.
Okay. Thank you, sir. Sir, Ijaya Babu Tekim asks, what is the procedure to get a geographical indication registered? Who can take it?
The procedure is, I think, then application is filed before the geographical indications registry. The application is examined. Then I think if there are any objections to it, those objections have to be cleared. Then it is advertised in the journal. There is the opposition period is 3 months, and if there is no opposition, then the GI is registered. And coming to the second part of your question, the GI can be applied by a group of individuals, a group of a community basically. So it cannot be a particular individual. It is an association of persons.
Okay, sir. Tanya Mehta wants to know, in case a lawsuit is filed, the infringement will be of the copyright or the design?
It actually depends on for which the lawsuit has been filed. I think looking at the pleadings, it could be depending the subject, what is the subject matter or the product that is involved. So it could be a copyright infringement or a design infringement. So looking at the subject matter of the suit.
All right, sir. Actually, so there's a lot of questions which are coming in for this.
Sure.
Yes, sir. So if two persons, this is Renuka Srinivasan, asking if there are two people filing an application for the patent at the same time for the same invention, to whom will it be given? Like, what is the criteria to differentiate?
I think the one who files it first, because I think if it's the same invention, the one who is filing it first will have a better right. So because if they are being filed on the same time. So I think the very important thing is, as you mentioned, it is the same thing. I think it should not be disclosed to anyone, the invention, because the moment it is disclosed, then it becomes a part of the public record. So it should not be disclosed. The first and the foremost thing is it should not be disclosed, even by the inventor himself, to anyone.
Okay. Yes, sir. Thank you, sir. Sir, Vandana Jha wants to know, when someone copies a trademark, what is the percentage that somebody is legally allowed to copy or use?
Well, I would firstly suggest, I think we should not be copying it. I think there is no percentage as such, but yes, the first advice would be to have a brand name which is distinctive, very different from the names which are already on the register or even which have not been registered. We are very tempted to have names very close to a famous brand names. So I think what we have to keep in mind, the brand owners have spent a lot of time and investment in building that brand. So coming very close to it, the brand owners would not like it. And yes, if if it's close to a brand, already an existing brand, and there's every likelihood that an action would be taken.
Okay.
So the advice is, in the first place, avoid adopting brand names which are very close to an already existing brand, and more so in the case of well-established brands.
Okay.
Like the
Okay,
big
sir.
ones which we have, I think, just for the examples, it could be the Puma, or it could be Reliance, Coca-Cola. So I think we should, the general principle should be to have names which are very different from the ones which are already there.
Some of the examples you mentioned in the presentation also, sir, I think was similar with the coffee and Colgate and all. People
Yes,
were
yes.
also copying the names, so that's very similar to that.
Absolutely. So you would have seen it, how even the labels also become a problem. You know,
Yes,
it
sir.
could be a color combination as well.
Yes, yes,
Let's,
yes.
for example, a packaging issue. You know, there could be two products, the Colgate example and the Coolgate, which I had
Yes,
left
sir.
in my slide. So the packaging as well was very close. So
Yes, sir.
and the test in the trademarks is, you know, the first impression that you get on looking at the products, and the microscopic comparison is not allowed. So it's the first impression that I have, whether are these similar or not.
Okay, sir. Sir, another category of question that we are getting is if Mr. Saket Saurav is written, can I get a book copyrighted if I have written the same? What is the procedure for the same? So, sir.
Yes, the answer to this is yes. The copyright protection is possible, and this would be protected as a literary work under the Copyright Act. And for this, an application has to be made to the Copyright Office, I think, enclosing the all the relevant documents. And I think as this I think the fee is also very nominal. I think I just mentioned in the slides. I think and the certificate is granted, I think, within 6 months of filing the application.
All right. The last question, sir, that we will be taking for today is what are the criminal remedies available against infringement of copyright and trademark? This is Aditya Gupta.
The criminal remedies is, I think, once a complaint is filed before the police, the person can be arrested, and the punishment varies from 6 months to 3 years, and along with a fine of from 50,000 to 2 lakh rupees.
Okay. Sir, another question. This is because of the relevance of this in today's time. I'll just like to take this. As IP, this is Bhumika Jain, sir. As IP is a territorial right, so when Coronel, being a registered mark abroad, is being used here in India, can that company file a case for infringement, or does that mark first have to be registered here?
See, there are two aspects to this question. A suit can be brought even without a registration. You know, even if my mark is not registered, the distinction is, if the brand is registered, then it will be a suit for infringement, and if the brand name is not registered in India,
I think the screen has just frozen. Just 1 second. Sir, can you hear me?
am I audible?
Hello? Yes, sir, you're audible now. I think there was just a frozen screen for a second.
Were you able to hear me or my answer, please?
No, sir. I'm sorry, but it just got stuck in the middle. If you could just please repeat.
Yes. So what I was trying to say is that even though the brand is registered in US, and it is still possible to bring an action even without a registration of a mark in India, I can still bring an action. However, that action will be for passing off, but not for infringement, as the question was. For infringement suit, the registration of a brand is necessary in India.
Okay.
But
All right.
but first and the foremost is the action can be brought. It is not necessary to bring an action that the brand name has to be registered.
Okay, sir.
Any more questions?
Thank you so much, sir. No, sir. Ones that were covering a lot of topics. Thank you so much, sir. This brings us to the end of this engrossing and informative session. I would like to express my sincerest gratitude to Abhishek sir for taking the time to enlighten us with this extremely helpful session. On behalf of MIM and BIEP, I would also like to thank everyone for attending today's webinar, as we also look forward to you all joining us for tomorrow's session. Once again, sir, it was really a pleasure. You really entertained our questions very well, indulged all of the questions. So very thankful to you. And as for everyone else, we'll see you tomorrow. Till then, stay safe, take care, and check out our YouTube channel, BIAP Official, for more such insightful and valuable webinars. Take care. Thank you.
Thank you. Thank you.
Thank you, sir.
Thank you.
Thank you.
Gibran. Thank you, ma'am.